Hello everybody, and welcome to your online lecture for criminal law. You can see by this slide that what we're going to be looking at today is the English law of murder. Murder is the most reprehensible crime in the English and Welsh canon. We're only dealing here with the law of England and Wales. Scotland has slightly different laws, so we're just talking about England and Wales here. Murder, as I was saying, is the most reprehensible crime, and it's reprehensible not only because it concerns the taking of a life, but also because it's the taking of a life with intention to take that life or to cause very serious injury. So we're going to be looking at the common law here, but only the actus reus. So we're only going to be looking at the action of the murder, not at the mens rea. So let's get on and see what we can discuss. So you would think that with such a serious crime, there would be statute specifically focused on this as an offence. You would think that our judges, our solicitors, our barristers would know exactly where to go, which statute to go to find out how to punish and prosecute this particular offence. However, the law of murder in this country is found under the common law. So the criminal law in this country is divided into two, or it comes from two different sources. There is statute law, which is something we're all familiar with, an Act of Parliament, the Theft Act, the Sexual Offences Act, all those sort of things. But there is also a branch of the law called the common law. Now the common law is based upon precedent, and it's judgments piled upon judgments, each one taking principles that have been made in the judgment before, so that you end up with a body of law that's based not on a statute, not on something decided in Parliament, but on real life cases that have actually happened and have actually been gone through the court and been judged and been punished and piled up on top of each other, so that the law gets clearer and clearer. At least that's the idea with all the passing cases, and we call this the common law of England and Wales. The offence of murder then comes under common law, and this is our definition, and you can see that it comes from Lord Coke, writing very early on in 1604. So this is a really old definition of murder, but it's still the one we use today. And if you ever listen to a programme on television, perhaps one of these police fly on the wall series, you'll hear if somebody's arrested for murder, they say, "I arrest you for murder contrary to common law." And this is what they're talking about. No statute, just this common law. And here is Lord Coke's definition. When a man of sound memory and the age of discretion unlawfully killeth any reasonable creature in reum natura under the Queen's peace with malice of forethought. Now that's the nugget of it. The rest of it is either expressed by the party or implied by law. And then we have a little bit in brackets here, so that the party wounded or hurt and die of the wound or hurt within a year and a day after the same. Now this little bit at the end, the bit in brackets, no longer applies because that has been repealed. So, in order to found criminal liability, we need any criminal liability for any offence at all, and so for murder as well. We need to find three things. We need to find that the accused has completed the actus reus, and this is the actual physical act. So for murder, it's an unlawful killing. For theft, it's dishonest, it's appropriation of property belonging to another, so it's different for each different criminal offence. The mens rea is the mental element required. So the mens rea for murder is the intention to kill. So while you're unlawfully killing somebody, you have to have that intention. We all recognise, don't we, the difference in, say, I knock into you in the street because I'm looking at my phone and you fall over and hurt your ankle. I'm very sorry, it's a mistake, it's an accident, fair enough. We all recognise that that's different to me walking up to you and shoving you on purpose so that you fall and hurt your ankle. Now, although your injury is the same in both of those things, it might be said that my liability, my culpability, is worse in the second one because I've intentionally harmed you, rather than it being because I wasn't paying attention or because it's we would call it an accident. So what somebody is thinking at the time they do the actus reus is very, very important. If you don't have the relevant mens rea for the crime, you're not guilty. In addition to these two things, you have to have a lack of a defence that is recognised by criminal law. Now, we're not going to be looking at the defences today. What we're going to be focusing on is the first of these things, the actus reus of murder. And here it is. This is taken straight from Koch's definition, and you can see that the actus reus is the unlawful death of a reasonable creature in being under the Queen's peace. Another part of actus reus, which applies to any result crime, is the principles of causation, because what the accused does, their actions, has to cause the death. Now that sounds very obvious in some cases. So if somebody shoots at you with a gun and you die of a bullet wound, then of course the shooting of the gun causes you to die. So that's very straightforward. But it can be very complicated. So these things have to be worked out so that we're sure that the person that has perhaps caused an injury has actually caused the death. So first of all, of course, we need to find out if a death is unlawful. And whether a death is unlawful or not, this unlawful killing suggests that there can be a lawful killing. And of course we all know that there can be a lawful killing. If somebody's acting in self-defence is a good example. So I'm not allowed to hit you with a chair so that you die, because that would be bad, but I am allowed to hit you with a chair if you're coming at me with a knife, because the law recognises that everybody has the right to defend their person. So what we're looking for here is a death that occurs when somebody isn't acting lawfully. So there isn't what we call a justification in law for me acting how I do. Excuse me. So the first of these things that we're looking for then, of these actus reus elements, is that the person concerned, or the thing that is unlawfully killed, is a reasonable creature. And we have to look at this and say, well, in our modern language, because of course Koch was speaking a long time ago, what is a reasonable creature? This is a picture of my dog. His name is Bruce, and he's asleep. If you killed him, would it be murder? Now, the straightforward answer to this, of course, is no, because Bruce, sadly, is not a reasonable creature, because he's a dog. And what the law says is that only human beings are reasonable creatures. Okay, so that's a very, very straightforward thing. You have to be a person to be a reasonable creature. Our next consideration then is everybody, every human being, a reasonable creature? There used to be a time, some years ago, in sort of Victorian times, we're talking 100 years ago, when not every person was a reasonable creature, and there was a concept of what they used to call a monstrous birth. So if a child was born who was very badly physically or mentally disabled, not that you'd be able to tell if they were mentally disabled, if they were very malformed at birth, then the doctors, the parents, whatever, would consider that this wasn't a reasonable creature. It was a monstrous birth, and therefore if this child died, or was allowed to die, or even was actively killed, then it wasn't murder because they weren't a human being. Now, clearly this isn't something that we look at now. It's not something that we would support. It certainly isn't something that the law supports. And we know this particularly through the case of Re A. Some people might remember this case. It concerned two conjoined twins who were called by the media Jodie and Mary, and one of the children was apparently a complete and healthy little girl, and the other child, although attached to her, was very severely disabled. It would have had very, very little brain development. They thought she was blind, probably deaf, and crucially had no functioning heart and lungs. The idea was to separate these children in order to allow Jodie, the healthy twin, to live a complete life, a full life. The doctors were of the opinion that if Jodie and Mary stayed joined together, then the strain of keeping Mary's circulation going would prove fatal for the stronger twin, and both of the children would die. However, they considered if they separated the girls, then Jodie, the healthy twin, would go on to live a normal life. But the question was, if the children were separated, the babies were separated, when the doctors knew that by separating them they would kill the weaker child, Mary, then would it be murder to separate the children? Would it be murdering Mary? She had no functioning heart and lungs. She was incompatible with life once separated from her sister. The judges, obviously this went to court, and it was decided by what we used to call the House of Lords in this country, now the Supreme Court, that actually, yes, it would be. So if the doctors separated the children, knowing, intending that Mary would die as a result of this, then an act of murder would have occurred. Because Mary, said the judges, in spite of her very, very limited physicality, in spite of her very limited mental abilities, and the fact that she was missing a functioning heart and lungs, was still a human creature and was as entitled to her human dignity as any other person. So the idea of any human being being a reasonable creature is something that's firmly cemented in the English law today. As an aside, of course, the operation did take place. Mary did die, of course, but the defence of necessity was found for the doctors so that the operation could go ahead. And Jodie has grown up to be a normal child in every way, so a good outcome from that point of view. So any human being is a reasonable creature. The next thing that has to be worked on is whether a person is in being. So we have our reasonable creature, and we have to say, are they in being? Now, what we mean by this is, are they alive? Now, this seems to be a bit of a given. You can't kill somebody unless they're alive. So, and again, this is, it sounds like something you're never going to have to define, you know, when is somebody alive? But actually it gets quite complicated. For instance, we have, I mean, when is somebody alive? When are they dead? Is it when their heart stops beating? Is it when they stop breathing? What if somebody's on a respirator? What if somebody's on a heart-lung machine that keeps everything going and is having their blood filtered and, you know, is having all this organ support? Are they alive? Of course, we want to say yes, of course they are. If you unplugged a person who was being kept alive on those machines and you weren't doing it in their best interest, you weren't a doctor or something like that, then of course you would be killing that person. We'll recognise that. So the law recognises death of a person when their brainstem dies. And this follows the medical model. A medical person will tell you that you're clinically dead when you have no operating brainstem. And your brainstem, as I understand it, is the thing that keeps your automatic reflexes going. It makes you blink, it makes you swallow, it makes your heart beat, it makes your diaphragm expand so that you breathe, all those sort of things. The brainstem, in fact, is practically the only thing that's still working where we have somebody who is minimally conscious. And we did have a case called R.V. Bland, again, which some of you may remember from a stadium disaster where a lot of people were crushed, and this person was still alive 5 or 6 years later, but just his brainstem was alive, and that led to another criminal case about would it be lawful to allow this person to die because his brainstem was still alive, and therefore he was still alive, he was still a person in being. So that's one end of life. What about the other end of life? When does a child in its mother's womb become a person in being? Is a baby, is a fetus, as we should call it, inside a lady, is that a person in being? Now the law says not. The law says that you are not a person in being until you have been expelled from your mother's body and until you have taken your first breath. And we have a very old case from the 1800s, the case of Poulton, which confirms this. If a child is born and hasn't breathed, then it has been born dead. You can't kill that child because it hasn't breathed. So therefore it has never been alive, and therefore it is not a person in being. Distressingly for some people, this means that even if a lady is very close to term and somebody injures her on purpose, maybe by injuring her stomach, by stabbing her or something, and the baby inside her is killed, then this cannot be murder of the child because the child is still in utero. However, this isn't a crime with no comeback, if you like, because we have a separate offence of child destruction. While it doesn't perhaps carry the emotional punch of murder, child destruction is aimed at just such an occurrence where a child inside the womb is destroyed or is killed, and it carries up to a life sentence, just the same as murder does. So it doesn't mean somebody's getting off killing the child, it doesn't mean they're escaping. It means that they'll be convicted of another crime, but not the crime of murder. One of the final element, I think, of the actus reus of murder is that it has to happen under the Queen's peace. Now, the Queen's peace is something that extends to the entire world. Okay, now obviously in Coke's time it was under the King's peace, and when we have a change of monarch and we get Charles III, then again this will revert to being under the King's peace, because the sovereign's peace for England and Wales extends to the whole world. And this puts murder in a peculiar situation, because anywhere in the world that a British citizen kills another person, they can still be charged and tried and found guilty of it in this country. So if you go to Australia and steal something and then come back over here, we don't care that you've stolen something over there. Okay, that was under Australian laws. You know, if you go back to Australia, you'll be arrested, but here, you know, we don't mind. However, you kill somebody in Australia and come back here, we'll prosecute you for murder, because the Queen's peace applies to the whole planet. Okay, and that's very few criminal offences apply out of jurisdiction. Some do, not many, and murder is one of them. Okay, so that's running through the actus reus of murder. You remember from the slide at the beginning that what we also need to match up with this, after we've had our unlawful death of a reasonable creature in being under the Queen's peace, we then have to have the causation. So we have to be sure that that act has caused the death of the person, and then we have to be sure that the mens rea is in place. And for murder, this is either intention to kill or intention to commit GBH. The law considers that if you're prepared to harm somebody, to cause them grievous bodily harm, and they happen to die of that, even if that wasn't your intention that they die, then you should still be liable for murder if your intention was to cause that person grievous bodily harm. We get our definition of intention in these cases from the cases of Nedrick and Woolin. However, that's not what we're going to be talking about here. That would be the subject of another lecture. We would also have to discuss, before we could be sure that somebody was guilty of murder, any general defences that they might have. So they might have self-defence, they might have another general defence that we could discuss, or they might have one of the partial defences that are just available to murder, which again is something that we would have to discuss before coming to a final conclusion about whether somebody was guilty of the offence of murder or not. I hope that's given you a little taste of the lectures and how they go, and I hope to see everybody soon.